I am Hamish, this is Stan, and this is Civil Banter.
We're civil litigators at Nelligan Law, helping people through injuries, insurance fights, and all of life's legal curveballs. Well, we are, for keen-eyed viewers, those with incredible perception, will notice a new recording studio. So here we are in the bowels of Nelligan Law in this new environment that has been brought up for us, and we're excited to get after it.
Yeah, and if you have suggestions as far as props, decor, please email those in to civilbanter@nelliganlaw.ca. And with that, we're going to jump straight into our first segment. This is Two Truths and a Lawyer. And in this segment, I have picked a bio of one of our esteemed Nelligan Law colleagues, and I will be saying two truths and a lie from their bio. Okay. So, Kiran Uppal. Kiran is an associate lawyer practicing exclusively in the area of family law. Her practice includes providing guidance on a wide variety of matters, including divorce, separation, child and spousal support, division of property, cohabitation, and marriage contracts. And I believe she was an articling student alongside Rianne when I first joined the firm. So,
that sounds like it was plucked exactly from her biography on the website.
it was saved for the details about in reference to when I joined the firm.
Right, the website doesn't care about when you joined the firm relative to Kieran's biography.
Yeah.
All right, fair enough.
Okay, so the two truths are within these three statements.
I got to pick out the lie.
You got to pick out the lie. So,
right.
In her spare time, Karen enjoys watching movies at the Bytown Cinema.
Sounds plausible.
Karen volunteers at a summer camp in Muskoka.
That's true.
Okay. Very confident with that one.
Yep. Unless you're playing games about where it's located.
In law school, Karen mooted and won a negotiation competition.
That sounds very plausible as well. I'm going to go with A and B are true and C is inaccurate or at best not true, maybe. I don't know. That's my guess.
Unfortunately,
oh no,
you don't know Karen as well as you thought.
She's a mooting champion.
In law school, Karen mooted and won a negotiation competition, specifically the BLG negotiation competition.
Okay.
And she went on to earn a coveted spot on the University of Ottawa's Walsh Family Law negotiation team.
Look at that. B is true, though, right?
B is most certainly true. Karen does volunteer at a summer camp in Muskoka. She's told me about it a couple of times. It sounds like a really amazing organization. It's called Campfire Circle.
Yeah.
And it's a nonprofit that helps youth and families affected by childhood cancer.
Yeah, she's a rock star for that stuff.
Yeah. The lie was, this is a tricky one. I said she enjoys watching movies at the Bytown Cinema. In actuality, she enjoys watching a movie at the Mayfair Cinema.
Okay, that is tricky stuff. Although I wouldn't have said that either were true. So there you have it. Okay. Big Blue Jays fan, massive Blue Jays fan. Karen.
That's true.
Yeah, beginning of a new season coming up. Hope springs eternal.
I don't think it would fly referencing that on the Nelligan Law website based on our historic Ottawa roots.
Fair enough.
So with that, we'll move on to the topic of the episode, which is a seasonal choice. We're talking slip and fall lawsuits, and the title of this episode is Grounds for a Lawsuit.
Nice punny title. We enjoy a pun here. And this one brought on in part by an experience I've been going through of late. My wife, unfortunately, slipped and fell and shattered her wrist. And so this is hitting close to home. She fell not in this jurisdiction, so not something we need to worry about vis-a-vis Ontario law, but provides a nice launching point for this episode for us.
Yeah, and this time of year, this is when the slip and fall claims start to come in.
Get that nasty freeze-thaw cycle a lot of the time, right? You get that sunshine in the day, some warmer temperatures, starts to melt the snow on the snowbanks, and then you get some some ice forming overnight when it inevitably plunges down. And if there's not enough salt on the road, or a sidewalk, it's pretty easy to not see that black ice fall and, quite significantly injure yourself.
Yeah, and they often are fracture producing. Wrist is obviously I mean, that's what your wife ended. That seems like it's the most common, perhaps followed by ankle.
Yeah, wrist and ankle. You fall and you brace yourself, right, with your outstretched
Yeah.
hand. And in the battle of bone versus concrete, the concrete typically wins. And it's a harsh one.
Yeah. And in terms of how the lawsuits actually work,
Why don't we hit with some need to know things?
yeah,
What should people take away before they get into the weeds on a slip and fall?
well, the need to knows, there's a number of different, I'm going to say stumbling blocks, but
The puns continue, folks.
so there's a lot of timelines in play here. So when it comes to municipal property, so sidewalks, city hall, anything.
Arenas, I think, probably would be covered in it. Parks, for sure.
Yeah,
Municipal parks.
parks would be a big one. You have a 10-day notice period if you have a slip and fall and it's related to ice or snow conditions.
And that notice period, what does that mean for our viewers?
The notice period means, and we'd have to dive into the act and give you the exact specifics, but it's essentially put the municipality on notice by sending a letter. Within the municipal act, it's by registered mail to a kind of registered mail, which no one even knows what that is. It's like mail, but a bit better because someone has to sign when they pick it up.
Yeah.
Or you hand deliver it, and the position of the person you have to hand deliver it to is the clerk of the municipality, whatever that means.
Yeah.
And so it's something where it's pretty difficult to actually get this done as an individual. Most municipalities, or a number of municipalities, certainly the city of Ottawa, does have an online platform on which you can provide a form of notice, but I would not be certain that that necessarily is good enough to comply with the Municipal Act. Maybe, like, I'd happy to hear differently from a City of Ottawa lawyer, but I know that if we're representing a client, I'm going to stick by the strict wording of the Municipal Act, because if you don't meet this 10-day notice period, it's going to cause big problems with your ability to sue.
Your claim is got the potential to be barred. Sometimes you can get around it. Obviously, if you suffer a really significant injury with, let's say, a head strike and you're out of it and you're in the hospital, you can get that notice period extended. But as a rule, we don't want to have to try and do that. So if you are seriously injured and you are considering making a claim, doesn't mean you have to make a claim. It just means you're protecting your ability to do so by letting the city know that you've fallen and you might pursue a lawsuit down the line.
Right. And one of the other difficulties we'll get into, which should be apparent as we go through this, but sometimes it's actually difficult to really establish where the fall happened and who owns it and what notice period may or may not apply.
Right. Is it City of Ottawa? Is it private property? Is it the National Capital Commission, as we see here? That's a uniquely Ottawa well, I guess got no problem as well, but it's something that we see here that you don't always see in other cities.
Right. And so that leads on to the next notice period. So this is if you have a slip and fall due to snow and or ice on private property, you have a 60-day notice period.
Yes, and that's in the Occupiers Liability Act.
Right.
And that's a fairly recent change. I say fairly recent. I think it's a few years now.
Mm-hmm.
But 60 days. So if you've fallen on snow and ice outside of a grocery store or just a friend's house or something like that, you would have to provide notice to the property owner or the occupier. They could be a tenant within 60 days of your fall, or you're at risk of having that claim barred by operation of the Limitation Act on that.
Right. And so, again, I was just thinking about, I guess it applies a bit, maybe less so in the winter, but Elgin Street, where there's restaurants that also sometimes have tables out there on a patio, but then a sidewalk runs through the middle. like establishing like who owns this, who is the occupier, is this municipal, is this private property. It really is something where you wouldn't want to just take your best guess at this. You would really want to make sure you had some certainty. It's relatively quick for us to be able to figure out. Not to say it's not complicated. um, in other situations, the general I'm injured, someone else is at fault, you've got a 2-year limitation period in which to sue. And to be clear, it's not, when we spoke about notice periods, I think you mentioned this, Stan, but it's not that you have to lawyer up and instantly get a claim issued, go to the courthouse, you're in trial in 3 weeks' time. It's
Yeah.
not that. It's
Wouldn't
that
that be nice though?
Yeah. It's the idea is letting the individual who might be responsible know that this happened. And then I suppose the principle behind it is, well, if it's a dangerous condition that I slipped and fell on, I should probably let the people know so that they can go investigate, remediate it, make sure that no one else is just going to repeatedly run into this issue. So it is kind of also just doing the right thing as well.
Totally. And I think there's an element of preserving evidence in there for sure as well. They want to be able to make sure that the logs about who was salting the road are available, and to make an investigation of the scene if that's possible as well. So
yeah, and that dovetails pretty nicely into what should you do when you have a slip and fall. And in the background of all of this is that, as your wife experienced, when you have a slip and fall and you fracture your wrist, probably your mind is not going to be, hopefully, realistically, your mind is not going to be on what legal steps do I follow. But
yeah, it definitely isn't. I mean, I lived through that, and the first thing was, okay, well, let's get you some medical attention and get to the hospital as soon as possible so that you can get it looked at, and you don't think about anything else. You're just thinking about minimizing pain. What do we need to do? Is surgery a possibility? And so that's really where you go first and foremost, is get the appropriate medical attention. And that's going to be our advice every time.
yeah, because at the end of the day, that really is all that matters. However,
shortly thereafter,
yeah,
you
with
could
that
start
being
to
said,
consider some other factors.
well, and this also applies to family members, bystanders, passers-by, friends. Like, if you're with someone who gets injured or you witness it happen, you can kind of just see it as a bit of your civic duty. It's not that much effort to go out there and document, and pass along, hey, I saw what happened, here's my number.
Well, we got some help. I wasn't there when it happened, so my wife had some help from bystanders who, in hindsight, unfortunately phoned off of her phone, so we don't know who they are.
Mm-hmm.
If they'd called me off their phones, then we'd have that information available, and I can thank them for what they did. But I actually don't know who they are, and unfortunately can't locate them. So if you're listening, let me know, and I'd be more than happy to thank you for that. But that also helps as a witness, and you can say, I saw what happened, and I saw where the ice and snow was. So you can get those witnesses to provide their statements about what they saw. They might also have been able to take pictures of the scene where the accident, slip and fall, happened. At certain intersections in Ottawa, there are surveillance cameras attached to mostly monitor traffic, but they no doubt would also capture sidewalk incidents and pedestrians. So the city of Ottawa has a website that you can go on that shows where the cameras are at the intersections, and within 30 days, you're typically able to access those recordings, and they will preserve them and email you a copy.
Yeah, and they're usually the bigger intersections. It's not every intersection, it's the bigger ones, but they have a pretty wide field of view. And they really could, if you had that footage, it really could make the difference between I'm struggling to prove the conditions at the time and it's black and white what happened. Another thing is, in residential or mixed use zoning areas of the city, ring doorbell cameras.
Yeah.
Like more and more people have their own doorbell cameras, or a camera on their driveway, and being able to just take stock of that, going to property owners that might be nearby. Most businesses have some level of video camera outside.
Well, I think
Being
you've got a case where we would watched some surveillance video from a building across the street from an accident.
Yeah, so those can just be really key in terms of when we're talking slip and falls on snow and ice. By the very nature of it, it can be very transitory. Like the ice is there, and then it's either treated, it's salted, the temperature changes, and it just is no longer there.
Right.
And if the basis of liability and the basis of your lawsuit, who was responsible, if you cannot prove what the conditions were at the time, it becomes increasingly difficult to successfully pursue the at-fault party.
That's right. Yeah. If you don't have any of that other evidence, you can rely on weather data that can show if it snowed or what the temperature changes were. And it is possible to sort of recreate what happened using that information, but it's a lot harder if you don't have any firsthand information.
Okay, and let's go, negligence 101 is there's a couple of different elements. One is duty of care. And so in a slip and fall, what does the duty of care mean, and to who is it owed?
Well, it's an occupier, so the owner or the person who literally occupies and runs the property will have an obligation, that's the duty, to invitees to the property. Those are guests or anybody who's permitted to access the property, to make sure that the premises is reasonably safe. So that's the standard. But the duty of care is that if you're going to have a property and it's open to the public, or you've invited guests to come to it, then you have an obligation to make sure that those people are reasonably safe when they're on your property.
Right. And then when we turn to standard of care, we look at the Occupiers Liability Act, as Stan mentioned. And the questions asked is, it's reasonably safe. You don't it's not a standard of perfection. That comes up a lot when we're talking about standard of care in different fields of law. One of the key considerations is basically what system was in place to prevent something like this from happening, and was it followed? And
Well,
then
was it reasonable first, and then was it followed?
So if the system in place you have is once every 3 months someone salts the property, that's not going to hold up.
Yeah. Yeah. If you are never shoveling your driveway and your system is I walk through the snow piling up on the driveway, that's not a system, so it's not reasonable. And we see these in every slip and fall case, whether it's on ice or snow, or if it's it's in a grocery store. Perhaps somebody slips and falls on fruit that's fallen onto the ground. Are they monitoring the floor? Do they have a sweep log? Do people monitor the weather conditions in the parking lot to make sure that there's something going on? Do they hire a property maintenance company, like a snow removal company? That's typically a way out for the owner or the occupier, but it might not be for the snow clearing company if they wait 2 days after a snowfall to come to a busy retail parking lot.
Right.
Standards reasonableness, as you said. So if it's actively snowing and it started 45 minutes ago and it's snowing like crazy and you slip and fall, probably don't have a claim because they can't get there to every single scene and it's just not reasonable. But if it's been piling up for hours and hours and it's a busy place, then it becomes more and more unreasonable the longer that goes unaddressed.
And another consideration after we get through those stages, even if it's been shown that a snow removal contractor or a property owner was negligent, next we're going to look at contributory negligence. And the idea here with contributory negligence is, am I the plaintiff who fell? Am I somewhat or am I partially responsible for my own injuries? And when we look at this, I mean, the most basic one we look at is, what was your footwear?
Yeah, if you're wearing flip-flops in the snow and you fall on some ice, there's going to be some contributory negligence on your part. If you're wearing your big, thick winter boots and they've got metal spikes in them and you still slip and fall, and I can't say that there would likely be a finding of contributory negligence there. We do see frequently contributory negligence on slip and fall, trip and fall cases. You have an obligation to look where you're going. And so we do frequently see minor contributory negligence in 5 to 10% on almost every case, but it's a unique assessment on the facts of each case.
Yeah, it really does depend. And other things that can go into the analysis, and it's fact specific, but often do go into the analysis, are, what was in your hands? What were you holding in your hands? Did you have your arms completely full and you were unable to break your fall? Also, alcohol use, other things that might impact your balance or dizziness, that could, in a way, contribute to the fall. And also, what did you know about this area? Like, had you been there frequently enough that you're extremely aware of exactly how treacherous the conditions were?
Yeah,
That can also play a role.
for sure. So there's just a few specific considerations we wanted to leave behind before we end the episode. The first one is we've talked a bit about the standard of care and reasonableness, but that's not always the case.
Right. So when we're talking municipalities under the Municipal Act 2001, the standard that applies to a municipality is actually gross negligence. And helpfully, it's not defined in the Act.
Yeah.
So we have to look to the case law. And the case law is, there's case law that flashes out what gross negligence means. It doesn't just mean negligence that's like gory.
Right. It's not.
It's gross.
Yeah.
It's
physically gross.
Yeah. Gross negligence, a concrete statement I can make is it's more than ordinary negligence. But it doesn't amount to
Intent.
intent. You don't have to
still negligence.
Yes.
It's not an intentional infliction of harm on somebody.
It's still, at the end of the day, a mistake.
Yeah.
But it doesn't get as far as being like, I intentionally did not salt and I just knew it was an issue and I let it go.
Yeah.
I mean, that obviously could be considered gross negligence and would be considered, but a lot of the time when it's assessing gross negligence, we look at the municipality's maintenance policy. Again, some of the same considerations. Was that a reasonable policy? And was the implementation of this policy good enough in this specific occasion? So it's looking beyond, what's the general idea when you have a system of inspecting sidewalks and salting them, but in this specific case, was that enough?
It's really hard to tell, and it's always fact dependent, right? So you could have a situation where, let's say it's freezing rain, aggressive freezing rain in the morning, and then the afternoon the temperatures go way up, and maybe the owners or the municipality says, we're not going to salt in the morning, it's going to get too warm in the afternoon, it's going to be a waste of resources. Well, if that's a busy rush hour, you've created a hazard and you've just decided not to address it, and I would argue that that's a situation where you could find gross negligence.
Okay, and on that happy note, we will say our goodbyes. Where can you find our team, Stan?
You can find us at nelliganlaw.ca, the whole team, Kiran included, and peruse the biographies and see what's out there. You could find me on linkedin.com/in/Stanford Cummings.
And I'm on LinkedIn at linkedin.com/in/H Mills McEwen. If you have comments, questions, or topic suggestions, as I said at the beginning of the show, if you have prop suggestions, please let us know. You can reach out to us at civilbanter@nelliganlaw.ca.
As always, like, comment, subscribe, and thanks for listening.
Thanks for listening. That's a wrap.